Ken, talk to me about evictions. I see so many conversations and topics online about people saying, I got evicted unfairly, or the landlord told me to get out, and do I have to get out, and what's the story with that?
Yeah.
What is the legal process behind being evicted correctly and having to actually go when you're not supposed to be there?
So what happens is, if a tenant lapses on their lease agreement and they do not pay their monthly rental, the correct process would be, once the landlord / owner comes to us and we take on the instruction, what will happen is we start the entire process with a notice of breach. So in that notice of breach, we then tell the tenant, listen, you're in breach of your lease agreement, you need to rectify the breach. If you don't rectify your breach, we will then proceed with what's called a notice of cancellation.
And there's a time period you get to do that action?
Yes, 100%. That is usually envisioned in the lease agreement itself. So the lease agreement will ought to have, not all of them have, and that's obviously a different type of avenue that we need to take, because then we need to follow legislation as well. But in 95% of the cases that we deal with, the lease agreement will have a default / breach clause where it says that if any party is in breach, you will give them 7 days to rectify, 10 days, etc. So in the notice of breach, we then tell the tenant, you have 7 days, 10 days, whatnot, to rectify your breach. If you do not do this, we will proceed with cancellation. So there's a few options that you can take here. You can proceed with what's called an application for specific performance as well, and that's where we head to the court and ask the court to give an order to actually force the tenants to comply with the lease agreement. In most instances, majority of the cases, we are dealing with, you know what, you're already a problematic tenant, I don't really want to deal with you, I'm going to cancel. So if the tenant does not rectify the breach, we then proceed with what's called a notice of cancellation. Most of the colleagues in the industry I know only does the notice of cancellation followed by the notice to vacate. What we do is we do a simultaneous notice of cancellation, notice to vacate, and in that notice we then tell them, we refer to our notice of breach, you did not rectify, therefore we are cancelling, and we are giving you hereby the X amount of days, usually 10 business days. If it's Consumer Protection Act, that's applicable. Otherwise, we follow the Alienation of Land Act, and that's 30 days notice, 1 calendar month's notice.